The United States Supreme Court just took the case the Second Amendment world has been waiting for. On June 30th, the court granted cert in Viramontes versus Cook County and Grant versus Higgins, consolidated the two cases, and allotted 1 hour for oral argument. As to Grant, the court only granted cert as to the question presented in Viramontes, which asked whether the Second and 14th Amendments guarantee the right to possess AR-15 platform and similar semi-automatic rifles. That is the question, and it's about damn time. Let's talk about it. Hello everyone, and welcome to the Firearm Firm channel. I'm your host, James Phillips, a founding partner of Katz & Phillips PA and a practicing Second Amendment attorney. And ever since the Bruen decision came out back in 2022, I have been dying to do this video, and the day's finally come. The United States Supreme Court will finally put to rest the infamous assault weapon ban that certain states and political parties have been pushing for years. The Viramontes petition sums it up nicely. The lower courts need guidance on how to apply Heller and Bruen to arms ban cases. That's exactly right. Because for years, the lower courts have treated the Second Amendment like a disfavored right. They read the Heller decision, they then read the Bruen decision, they recite the test, but yet somehow the government still wins nearly every so-called assault weapon ban case. That's why this cert grant matters. Viramontes comes out of the 7th Circuit and challenges Cook County's ban on so-called assault weapons. Grant comes out of the 2nd Circuit and challenges Connecticut's restrictions on semi-automatic rifles, including the AR-15. The Supreme Court has now tied these cases together around the same central constitutional question. Can the government ban an entire category of semi-automatic rifles that millions of law-abiding Americans possess for lawful purposes? Here's the key line from the Grant petition. It asks whether the Constitution protects semi-automatic rifles in common use for lawful purposes. That phrase is the heart of the case. Under Heller, arms that are commonly possessed by law-abiding citizens for lawful purposes are protected. The government cannot take protected arm, slap a political loaded label on it, and then say the Constitution no longer applies, even though they keep trying to do that. And that's why the AR-15 question is so important. The Viramontes petition emphasizes that the AR-15 is not some obscure fringe weapon. It relies on Supreme Court language recognizing the AR-15 as the most popular rifle in the country, and it argues that Cook County's ban reaches ordinary common firearms. Now pause there, because if the most popular rifle in America is not protected by the Second Amendment, then what exactly is protected by it? That is not just my rhetorical question. That is basically the point made in the Grant petition, which says that if the most popular rifle in the country is not in common use, it's hard to see what the phrase could possibly mean. That is a devastating point, because common use cannot mean common use only after the government is finished banning things. It can't mean common use only in states that still tolerate the right. And it cannot mean that common use only if judges personally like the arm at issue. Common use means what it says: arms commonly possessed by law-abiding citizens for lawful purposes. Here's where the cert petitions are especially strong. The lower courts have mostly reached the same result. They uphold the AR-15 ban, but they do not all get there the same way. Some courts say these rifles are too similar to military-style weapons. Some courts say they are unusually dangerous, and other courts say people still have handguns, so the Second Amendment is satisfied. Some courts go so far as to bury common use in the historical analysis, and others treat common use like a threshold question. The Grant petition calls that out directly, and I love it. That is a cert-worthy problem. When every court of appeals reaches the same anti-Second Amendment result, but the reasoning is all over the place, that is not stability. That is not doctrinal clarity. That is judicial workaround. And the Supreme Court has seen this move before. Before Bruen, lower courts used interest balancing to uphold almost every gun restriction. They would say, yes, the Second Amendment is implicated, and then uphold the law because the government said public safety. Bruin rejected that framework, but the cert petition argued that the same thing is happening again, but only under new labels. Now, before Bruin, courts diluted the right by balancing it away. After Bruin, they're trying to dilute the right by saying the arm is not protected in the first place. That is the fight. The Viramontes petition goes after the Seventh Circuit's logic hard. One of its sharpest points is that under the decision below, the Second Amendment protects very little beyond what Heller already specifically named, and that's handguns. The petition frames the danger as a rule that permits anything short of a complete ban on all firearms. That is the slippery slope in legal form, because if the government can say, you still have some other guns, then the right becomes a shell game. Ban AR-15s, but say you can have handguns. Ban certain handguns, but say you can only have revolvers. Ban modern semi-automatics, but say you can only have bolt actions. At some point, the right is no longer a right. It is a government-approved menu. The Second Amendment does not protect only whatever weapons remain after the legislature finishes carving away the rest. Now, the government side is going to argue that AR-15s are especially dangerous. They will point to mass shootings. They will use terms like assault weapons, military style, high-powered, and unusually dangerous. And we should be serious about the fact that these cases involve emotionally powerful arguments. Connecticut law, in particular, is tied to the political aftermath of Sandy Hook, and the other side will put that history front and center. But constitutional analysis cannot be driven by labels or tragedy alone. The Heller formulation is not dangerous or unusual. The historical phrase is dangerous and unusual. And the Viramontes petition presses that point, arguing that only arms that are both dangerous and unusual may be banned. That distinction matters. All firearms are obviously dangerous in the literal sense. That is why they are useful for self-defense. The question is whether they are both dangerous and unusual in the constitutional sense. And if millions of Americans own AR-15 platform rifles, if they are sold through ordinary commercial channels, if they are commonly possessed for lawful purposes, and if they are legal in most of the country, calling them unusual becomes very, very difficult. Another point this case needs to make clearly is that this case is not a machine gun case. An AR-15 is semi-automatic. One trigger pull, one round. That is the same basic firing mechanism used by modern handguns. The petitioners are asking the court to stop lower courts from treating ordinary semi-automatic function as if it automatically places a rifle outside of the Second Amendment. Because if semi-automatic operation is enough to make a firearm ban-worthy, then the logic doesn't stop with rifles. It reaches pistols, it reaches shotguns, it reaches the ordinary modern firearms Americans actually choose to own. That is why this case is bigger than the AR-15. This is about whether the Second Amendment protects arms as people actually keep and bear them today, or whether courts can freeze the right into a museum piece. The Second Amendment is not a right to own only obsolete, underpowered, government-approved substitutes. So what could the Supreme Court do? There are three realistic possibilities. First, the court could issue a broad ruling that AR-15 platform and similar semi-automatic rifles are protected arms, they are in common use, and the categorical bans are unconstitutional. Second, the court could issue a narrower ruling correcting the methodology. It could say the lower courts put the common use in the wrong place, shifted the burden improperly, or smuggled interest balancing back into the analysis. Third, the court could uphold the ban. That would be a major loss, and it would give hostile jurisdictions a roadmap for banning more modern firearms, and I believe that's the least realistic outcome. But the fact that the court granted cert after repeatedly relisting these cases is significant. Now, it doesn't guarantee the result, and it does not mean 5 votes are locked. But it means at least 4 justices thought this question needed Supreme Court review now. And that alone tells you this issue has reached the point where the court may finally have to decide whether lower courts can keep narrowing Heller and Bruin into practical irrelevance. Here's my read as a Second Amendment lawyer. The petitioner's best argument is simple and powerful. If an arm is commonly possessed by law-abiding citizens for lawful purposes, the government plainly cannot ban it. The other side's best argument is also simple. These rifles are uniquely dangerous and states need room to address public safety. The question is whether the court will let public safety rhetoric override the constitutional text, history, and tradition, and I am betting they don't. And that is where Heller and Bruen really matter. Heller did not say the government can ban common arms if judges believe other firearms are enough. Bruen did not say courts can balance away the right whenever the government invokes crime or fear. The Second Amendment is not protected by asking whether the government has left citizens with some alternative tool. The right belongs to the people. So here's the bottom line. Viramontes and Grant are not just about Cook County. They're not just about Connecticut. They are not even just about AR-15s. They are about whether lower courts have to take the Supreme Court seriously when it says the Second Amendment protects arms in common use. They are about whether judges can redefine the people's arms out of the Constitution. They are about whether the government can ban the most popular rifle in America and then tell citizens, oh, don't worry, you still have something else. That is not how constitutional rights work. A right is not protected only when the government likes the way you exercise it. A right is not protected only when the tool is old, rare, weak, or politically harmless. And the Second Amendment does not say the right of the people to keep and bear arms, survive legislative hostility, shall not be infringed. It says what it says. Be sure to let us know what you think of this video down in the comments section below, and don't forget to like and share this video. As always, if you have any questions about this video or any other Second Amendment related question, don't hesitate leaving your question down in the comments section, or you can email your questions directly to us at questions@thefirearmfirm.com. Until next time, stay prepared, educated, and of course, protected.